outset that this is not the sexiest case that could possibly be run. It does not involve hookers and blow or polar bears. I would just like you, Mr. Speaker, to bear in mind that the alternative was a case about the gold standard. So bear that in mind. Mr. Speaker, the case that I want to put before the House today is that this House would adopt a system of universal and mandatory public insurance. And I'm going to take a while to model this out, Mr. Speaker. So what we say is that in Canada, for every instance of personal injury where the person who is injured was not at fault and where they are injured by an individual or a corporation, we would provide government compensation that was not currently covered by the healthcare system. So we're talking about things like rehabilitation, retraining if necessary, things like payment for time off work, and things like a personal care worker if that becomes necessary. And the money for this will come out of government general revenues. This is a government program funded by government tax dollars. But where we think this gets contentious, Mr. Speaker, is that in order to effect and pay for this system, we are going to take away an individual's right to sue the tortfeasor, the wrongdoer in this case. And we're going to have the government subrogate their claim. And so that means the government can sue the person, the government can sue them and obtain punitive damages against them. They would have every remedy the individual would have, but the individual will not benefit from any of that money. They will get the government compensation, whether they would be able to sue in court or not, but the government can advance the claim. The other thing I would tell you, Mr. Speaker, is that this is not functioning all that different than the principles of workers' compensation. It is simply too large. They also do this in New Zealand. I have 3 points, Mr. Speaker. The first is practical justice, the second is philosophical justice, the third is litigation culture and access to justice. Josh is going to talk about the role of the state, because we had to do that, and workers' compensation as a case study. Mr. Speaker, I want to talk about practical justice, and I want to begin this case with the thought experiment that underlies it. Imagine 2 identical people get hit by an identical car traveling at an identical speed. But in one of those cases, the driver stays. In that case, Mr. Speaker, the person can sue and get compensation. They might even get punitive damages, Mr. Speaker, for that. But in the other example, the person takes off, or the person is uninsured, or is poor, or whatever. That person gets no compensation, they get no remedy, and they have no access to justice whatsoever. And what we would say on our side of the House is where 2 individuals have the same need, where they are similarly situated, they have the same loss, it is impossible for the state or any just society to justify a serious differential in their outcome, Mr. Speaker. And what we would tell you is that it's one of the roles of the state to smooth out the arbitrariness of fate. And we see this in a lot of the things that the state does, whether it pays for people who are born with a disability to receive certain kinds of education and healthcare entitlements, where we take people who are from disadvantaged, racialized backgrounds and create programs of affirmative action. We think that this is in a similar boat, Mr. Speaker. Because you said please.
This is a reason to have access to public civil lawyers. It's not a reason to have public insurance.
Okay, you're going to have to explain that a lot more, like in your constructive points. I don't understand what you're talking about at all. Like, the other thing I would tell you, Mr. Speaker, is that government is better able to advance these claims. That's my entire third point. But what I would tell you, Mr. Speaker, is we accept that many individuals will feel that losing the right to sue blocks their path to accessing justice. But what we would say is that in the interest of having a situation where every individual is covered, we would much prefer an imperfect practical justice for the vast majority of people to an imperfect theoretical justice for only some of them. And that's the principle that Josh and I stand on in this debate. The second thing I want to talk about, Mr. Speaker, is philosophical justice. I'm going to talk about Aristotle and Rawls because I can. So the first point, Mr. Speaker, is that it is a basic principle of formal justice and formal equality that we treat like-situated individuals alike. And I really think it is, like, I don't want to throw down the gauntlet, but it is going to be Jake and Sophie's burden to tell you why we justify the differential in outcomes for these 2 people. But the second thing I want to talk to you about, Mr. Speaker, is Rawls, who had this idea of the veil of ignorance, which is that in any just society, justice is where everybody can agree on the rules from a neutral perspective. So if you were a person who didn't know which driver was going to hit you, Mr. Speaker, we think that we would need to set up a situation where both people would be covered. And so I also want to tell you, Mr. Speaker, my third point now is about litigation culture and access to justice. Because in Canada, Mr. Speaker, to advance a civil claim, even a meritorious one, is incredibly expensive and incredibly difficult. The average personal injury case from the defendant's side costs over $80,000 to wage, and at a very minimum level, Mr. Speaker, will take more than 2 years. And we think that very few people, like even middle-class people, have the actual means to pursue these claims to their logical and successful conclusion and obtain any manner of just compensation. We would also tell you, Mr. Speaker, that in Canada we have radically lower jury verdicts than they have in the United States, which means fewer lawyers are actually willing to take cases on contingency, which means that very few people have the $80,000 and 2 years of their time necessary to invest in a claim. And we think that this does 2 things. It denies those people, a vast number of people, justice, but it also lessens the state's ability to deter this behavior, Mr. Speaker, because so many people can't sue. And we would also tell you, Mr. Speaker, that these barriers discourage a lot of people from seeking a remedy, but they are particularly pernicious in the case of poorer victims, Mr. Speaker, because if you are poor and you are also injured, then it is even more difficult for you to seek any kind of meaningful remedy. And what we would tell you on our side of the house is that this simply creates a vicious cycle where people who are hurt and are already poor are then subject to less perfect justice. And we think that that's a problem. And we would tell you, Mr. Speaker, that even if you had the means to pursue this claim on your own initiative, it is just like something insurance companies are ridiculously good at grinding people into the ground, Mr. Speaker. They have resources, budgets, abilities, and incentives that the average individual does not. And obviously, Mr. Speaker, we don't claim that we're going to make this entirely go away, but what we would tell you is that the government is going to relieve the individual of the obligation and the burden of pursuing justice on their own behalf and on behalf of society. And we think government can effectively advance these claims in a lot of situations. The government litigates really, really well. They do it in the criminal law context, they do it when you get a speeding ticket, they do it in terms of tax litigation, Mr. Speaker. No, thank you. So we think that the government will sue these people, and in many cases they will be more successful in suing these people, which will actually increase the deterrent effect for people to be negligent in our society when they know, Mr. Speaker, that there are a set of known rules. It creates certainty for victims, but it also creates certainty for wrongdoers, Mr. Speaker, because they understand that the government is much more likely to go after them. We think, Mr. Speaker, it is a fundamental principle that in something where it is important, not only for the individual, but for the society itself, Mr. Speaker, to gain access to justice, we think the state has a role in helping the individual achieve it. So what have we told you today, Mr. Speaker? We think that we need to have practical justice, we need to have philosophical justice, and we need to change the rules of the game so that individuals are compensated. And also we would tell you, Mr. Speaker, that even if the individual was able to sue and get a punitive damage claim, we don't think that that's any more legitimate either, because that's a windfall to them, because that's money that is given to them for the purpose of deterring wrongdoing, Mr. Speaker. We think that people should be compensated for the losses that they actually receive, not losses that are imposed by society. We think the government can take this, they can make it fair, and they can make it work. For all of those reasons, I'm very proud to propose.
I thank the Prime Minister for introducing this interesting and contentious case, and I would invite the first speaker on side opposite to present the case for Majesty's Loyal Opposition.
Thank you very much, Mr. Speaker. I love this case. I love that it's a law and economics case. It's not like the gold standard or anything, but I'm going to play ball with it. I have two constructive points. Firstly, I'm going to talk about incentives on behalf of the person who was injured, as well as on behalf of the injurer. Secondly, I'm going to talk about why the government is a bad body to conduct a civil case with themselves as the plaintiff, especially because they're also responsible for the criminal investigation. Haha, foreshadowing. Then I'm going to go through what we heard on side government, and I refute all that. Before I start, though, I kind of want to outline a counter case of sorts on behalf of side opposition, because Sophie and I recognize that we do need to provide a mechanism for those cases where people cannot sue for restitutive justice because they don't have the economic means. We think a reasonable way to do this is to provide public access to lawyers who will help you advance your civil claims in court if you are unable to advance these claims because of your lack of means to do so. We think a reasonable way to implement this type of protection is to still have the plaintiff be the individual who is directly affected by the injurious party, and we think that this is a better system for achieving the types of outcomes that both sides of the House probably agree are good. Is this a clarification?
No.
Okay, sit down. It's been a minute. So on the first one, right, on incentives, a little bit about insurance theory, Mr. Speaker. So first of all, recognize that they don't have a system for determining deductibles for people who are collecting insurance. So I think furthermore, even if they were to propose this type of system in the second speech, I think it's actually highly problematic for the government to get in the business of determining the extent to which their citizens are responsible for their own actions, setting different variant options for how much they ought to pay in the event of an accident. So at the point at which you have made someone indifferent between collecting the money for a personal injury or a damage to your property, if you parked your car on an unsafe street and it was hit by someone, I assume that this has to be included by their case, then you've actually removed the incentive for individual responsible behavior. Because part of the reason why we actually try to maintain our own safety as well as the safety of our property is that it's a hassle to have to pay the $500 before you actually start collecting from the other company, before you start collecting from your insurance company. I think it's actually highly problematic to place all individuals, each of whom have different risk profiles, in the same category, because then all the problems of moral hazard, compounded by the fact that there's like adverse selection, people who buy insurance, there's no ability, if you're a responsible person, to have access to the lower rates to which we think you're actually entitled because you are, in that sense, more responsible. Go.
Okay, with respect to moral hazard, like this is personal injury and people don't get any windfall from it. Why would you injure yourself if you only get the compensation for like your rehabilitation? There's no incentive.
So it's weird that you would make a point about like litigation culture while also claiming that people are like always like in effect not happy to sue in return for lots of money when they are injured. I think there actually is a problem wherein people are willing to get large sums of money if like it compensates them for their injury. I think they're actually like, it is plausible that there are people who would say, I don't need to be as safe because I will be fully compensated. No, thank you. Secondly, I want to talk about people who are guilty. I think these people are less likely to be held to account because the government will have less of an incentive to sue them and to collect back on those payments. So why is that the case, Mr. Speaker? And this sort of transitions into my second point. So recognize that once the person who is injured has been paid off for that injury, they have no incentive to continue to provide information that is relevant to achieving justice in a civil trial, Mr. Speaker. That's why it's better to allow them to be the agent of their own lawsuit, because they are the ones who are best equipped to achieve that just outcome in court. I think when you have the government that is responsible for collecting money in many small situations from many different actors with public servants leading the charge and like no one pushing them and like no direct interest behind that lawsuit, I think it's very likely that they will be less likely to collect on all of these claims. I think when you are less likely to be collected upon when you injure someone, you are in turn less responsible for your own behavior as if you're someone who places others at risk. No, thank you. I also think, an interesting way, I have interesting law points too, that it's a problem to have the same party conduct the criminal investigation in the case of it like a hit and run or something, as well as the civil investigation. Because we recognize that in a criminal trial we accord the prosecutor the right to achieve information through methods that you would not allow private individuals. On the other hand, recognize you also now have basically the same office providing the civil as well as the criminal aspects of that trial. We think that that's a problem. It's subject to abuse. Go.
Okay, but if you defraud the government, they both handle the criminal and the civil thing, and we all think that's okay.
So we think that's a special case in which it's unavoidable for that to be the same party. It's not a good thing for that to be the case because it does place people at the risk of being subject to the enforcement of the criminal trial, which may allow information to be given to the civil plaintiff, which would be unfair in any other case. So what did we hear on side government? So the first thing we heard was about people's practical abilities to sue. And I think Sophie and I can effectively cut this out of the round by giving people an alternative method that allows them to sue, but under their own name, and to retain those winnings for themselves. So to the extent that at the end of Brent's speech, he makes a point about people not receiving the punitive damages in court for those actions, I think we actually recognize that this is probably more of a case for taking away punitive damages rather than actually a case for not allowing people to collect damages themselves. So the restitutive and the parts should still go to that. The second thing they talked about was about a philosophical justice behind trials, right? So we think another aspect of looking at these types of cases from behind the original position is how you maximize the activities taken by people so that they behave in the most responsible way possible. I think when everyone behaves less responsibly, you have less to distribute to individuals within society. Sophie and I provide you a plan in which people behave responsibly because they have personal incentives in the game. Lastly, to talk about why the government is better to address the claim, to talk about this a little bit in my perspective. For all of these reasons, we're proud to oppose. Thank you.
I thank the members, the leader opposite for his address, and I would invite the Minister of the Crown to continue the case with side government.
Here, here. All right, thank you, Mr. Speaker. I have 3 more arguments, and then I'm going to go into some refutation. Don't worry, they're not that big. Okay, so the first one is how, under the status quo, the pursuit of distributing loss within society through tort creates arbitrary punishment. I think that's really that's a huge problem that needs to be addressed. So under the status quo, judges and the judicial system often wants to compensate. They seek compensation because they recognize the lack of justice that occurs when an individual is clearly harmed, but no other individual has the capacity to compensate. So if you're hit by someone in a car and they don't have insurance and they're poor, there is no just way in which you're able to seek compensation. And what the courts tend to do when faced with this dilemma is that they're more willing to be flexible in their application of finding negligence for the means of seeking out compensation, right? So I'll give you a clear example. You can often have a suit where, a bouncer will throw out an individual from the bar and the individual will be injured, right? The bouncer was negligent in the way in which they conducted themselves. The bar may have even trained the bouncer very well and were not negligent in the way they approached hiring the bouncer. Nonetheless, if the bouncer himself is not insured, that the claimant, what will occur is that the claimant will sue the bar for vicarious liability. And the reason that they'll do that, and the reason why they can do that, despite the lack of negligence from the bar, is that the courts are willing to be flexible and assign negligence to the bar for the purpose of seeking out compensation. They think it's too lacking in justice to not allow the individual to have compensation when they're faced with the dilemma of not being able to find someone who concurrently is negligent and insured. We think that is very negative because the bar didn't do anything wrong. The bar wasn't negligent. We think it's very harmful to use this flexibility to arbitrarily apply negligence. We think that's really problematic. Second thing I want to talk about is the role of the government. We think that the role of the government, many roles of the government are served for this. First of all, it's really important to actively promote justice and equality. And I think what my partner Brent has shown you is a number of ways in which this is one of the only ways in which we can actually ensure equality when it comes to tortfeasors and people trying to seek out justice and compensation. The second thing I would say is the notion of establishing important norms. And we think that the norm of equal treatment and allowing people to equally seek out compensation when harmed in similar circumstances is another important norm that it's important for the government to communicate to general society. We think that the government does send a harmful message when it constructs a system in which individuals can be harmed in identical ways and have no avenue of redress or compensation. We think that's problematic. Thirdly, an issue of deterrence and the notion that it's far more effective to be deterred knowing that there is an individual who will certainly have the resources to pursue you. I have a number of responses to what Jake says. He says 2 things that we ought to be arguing. First, he says that we ought to be arguing for creating public civil lawyers. There's a number of responses to this. And the main response to this is that it doesn't respond to the majority of cases that we're talking about. The majority of cases in which individuals are injured by people who run off or people who are uninsured. By having public civil lawyers, it is in no way addressed. The public civil lawyer cannot pursue no one. The public civil lawyer cannot give them insurance and then sue them, right? That's why we're creating a board which compensates everyone, so that independent of the circumstance of being insured, you're still able to seek compensation. So I don't think that that's a response. Additionally, he said, why do they want to ban punitive damages? Because we don't dislike punitive damages. They're important because they serve a deterrent effect. We dislike punitive damages to the extent that they act as an arbitrary windfall to the individual who wins them. If it's a social and policy objective to use punitive damages as a means to encourage individuals to act more responsibly, we think that giving that to the government, which is what would happen through our model, is a much more logical and sensible thing to do. Again, when we're talking about arbitrary justice, we think it's problematic to give punitive damages to individuals who really are just seeking compensation. We think that compensation is the key just outcome for the individual who has been privately injured. And then the last thing I'll talk about is just this notion of the case study of workers' compensation, right? We think that this notion isn't like a special case. We don't think that workers' compensation is this weird thing where the individuals should all be compensated equally. We think that the principles underlying workers' compensation are universal and transcendent in the way that they should be applied. We do think that it's reasonable that if injured as a worker or otherwise, that you ought to always be able to seek compensation and redress for the harms that you accrued, whether or not you're in a circumstance in which the individual may not have been insured or may have just run off. We think that these are all substantial benefits. Now, what do we see from this side? There's 2 different things. First of all, there's talk of incentives, and there's talk of how the government is the worst actor to do this. In terms of incentives, there's also interesting arguments. First, they spoke of how there's less of the need to act safely? I think there's two important responses. First of all, for the person who's injuring, I think there's more of a need to act safely, knowing that an individual with resources, i.e. the government, will always be able to pursue their claim. I think a lot of companies get off on the idea that they don't really need to act that safely, especially when employing low-income workers, knowing that most of them can't even afford seeking redress. I do think that that's a problem. Additionally, what I would say, however, is that first of all, if they're talking about the person who's injured acting unsafely and not worrying about it, the first thing that's important is that if they're acting very unsafely to the extent of being negligent, then they aren't covered, right? Like obviously you can't seek out redress for self-inflicted injury, right? So these people can't be acting outrageously unsafely in terms of the incentives. But additionally what I would say is that only compensation ought to be given to these people, right? So I've already shown you why it is the case that that's just. I also think that for these individuals, whether or not they're acting somewhat unsafely, if they are injured and for the most part it is caused by another's negligence, we think that the only remedy ought to be compensation as opposed to punitive damages. The next thing that they talked about was the injurer. And I think I've already clearly illustrated to you why it's the case that the incentives presented to the individual who injures are much better. Yes?
If I'm a safe 55-year-old or above driver, I can go to that company that gives insurance to old people and has less premiums. I can't do that under your plan.
Okay, yes. So I understand that we're taking away the individual to pay like lower premiums and spreading the tax dollars around. I understand that, right? So if you're really, really safe and you want to pay somewhat less premiums, we are taking away that right. But like that was admitted right in the model. What I would say to you is that we think a system is like absolutely more just when all individuals, independent of their socioeconomic background, are able to pursue compensation. And if that means some people have to pay a little bit more, we're absolutely fine with that difference, right? We don't think that that's a problem that is overwhelming in terms of the interest of that person's liberty, that the interest of compensation is much more important. And I'd point you to a counterexample, right? Like, sure, the old driver to pay lower premiums. What about the poor person who can't pay the premiums, right? What about all of the people who just can't afford insurance? All these people are ignored under your model. Certainly they have the liberty to get premiums that they could never afford anyways. I think that the actual liberty of people wanting to be insured is far more actualized in their model that ensures that people are insured. So I don't think that that's a response to this. The next thing that I talk about is how the government's a bad actor. The first thing they said was like crime and civil trials will sometimes intersect. I think there's tons of cases in which this does occur. Like it's kind of problematic. It's also kind of asserted to be problematic, right? So if you defraud the government, that's one example. That's not the special example. If you commit tax fraud, like if you hit a government truck while driving, all these are cases where yes, unfortunately, criminal and civil intersect. I don't think you can assert that there'll be tons of corruption or something as a result of that. Additionally, what I would say is that he said that the government shouldn't assess responsibility because they're bad at that, which is what the government does with like fines and stuff all the time. So I don't think that the government's necessarily bad at that. I think they have tons of resources in order to do that. Whose time?
You're at 7:30.
Yeah, I'll stop because I'm over. So. That's very kind of me. Okay. Okay.
Sophie, you're up. Let's keep this rolling. Apologies to everyone.
Thank you, Mr. Speaker. So I think a really important part of the case that I'm going to talk about in my constructive is that this side of the House basically takes away your ability to decide whether or not you want to sue in a civil case. And we think that's really problematic, right? So the reason I think this occurs is because if the government is paying these people compensation and that kind of thing out of tax money and out of money they get out of suing people for damages that the government takes and that kind of stuff, we think that they always have an incentive to sue people if they get in a car accident or if the state becomes aware of some situation where someone was negligent and there was harm done to somebody. Because it puts more money in the coffers to be able to compensate everybody and it's less of a burden on the tax system. So we think that the government always has an incentive to sue in a tort case. Why could this be problematic? So Mr. Speaker, if you are the victim of a civil case, there may be good reasons for you not to want to sue depending on who the actors are. In fact, it might be more harmful for you and your family situation and any of that kind of stuff if a tort proceeding goes forward than if it doesn't. So for example, if I'm hit by a car, but it was my mother or my significant other or something like that driving, then I am the only person who's damaged. And it may be worse for me to go to court, and it may be worse for me to get to have them pay damages and that stuff like that. Maybe it's not worth it to me to claim any kind of compensation, but they will still be sued. And I do think that's important because this side of the House takes away the right for the individual to decide what the degree of harm to them is, which is very critical in the decision whether or not to sue in a civil case. Recognize, Mr. Speaker, that the distinction between a civil and a criminal case is the degree to which the crime or illegal action affects the state and affects everybody in the state. So if it's designated civil, the court has already, or the government has already decided that this particular kind of action visits harm upon the person who is the victim, but not upon general society. So that's why certain types of crimes, I don't know, hit and run, maybe gang activity, that kind of stuff, those are criminal procedures because that affects public safety broadly. But not everything affects public safety broadly. But in this case, we think we're going to have every single case going to court. Another example might be something like if a parent is abusive or inflicts harm upon their child, and the guardian has the tort right to sue for damages on behalf of the child, they might not want to do that. They might not want to bring the child to court. I know, I'm not sure if it's legal in this jurisdiction, but for example, suing your mother for giving you FAS, that's a controversial thing that could occur in some jurisdictions. I know it's been a case of this tournament. So that might be a situation where you wouldn't want to have a tort case about it because or you would want to be able to decide not to go to court for that because it would be really damaging for all parties involved. And in this case, we think that the state takes away individuals' right to make that decision. And so Jake and I think that all of the harms that they present to you with people not getting compensation are distinct from the problem of assurance and the right to decide whether or not you want to go to court in a civil case. And we think that this is a harm that they can't take away on their side of the house. So now I'm going to get into some refutation. So I'm going to deal with Josh's new constructed material. So the first thing he tells us is that, sure, actually, why not?
Is it important to encourage responsibility whether or not you cause harm to family members or otherwise?
I think the nexus where the state has the ability to make that decision is where they decide whether to designate an act a criminal offense or a civil offense. So the state can make that distinction about how important responsibility is versus people's ability to decide to get compensated or not. But it's not at the nexus of making everyone have public insurance. It's deciding whether to make something a civil crime or a criminal crime. And we don't think that in all situations you necessarily want the state to be grinding down on people and making them taking all of these actions to make people as responsible as possible because there might be some negative externalities you want to give people the option to avoid. So the first thing Josh tells us is that courts make people pay even if they're not negligent. So I think this is probably a problem with legal procedure, right? So maybe you want to have higher standards for courts making people pay out in tort cases if they're actually not negligent. I don't see how giving another avenue for the court to get money out of someone to pay a poor person actually fixes this problem. And I think, so I don't think this is really related to the case. It seems a bit of a roundabout way of fixing it. I also want to point out that we think that in an ideal situation, people do have things like healthcare, Medicaid if you're in the United States, welfare, and the amount of just sort of basic income the state provides to people is the state's way of ensuring that people are able to live a reasonable life or have the tools that they can get to construct a reasonable life for themselves. So we think that that is enough to take care of people who are poor and people who would not be compensated if there is no negligence. So we think that's the way you take care of people who are at the low end of the socioeconomic spectrum and that kind of stuff. Then he talks about deterrence and he says that public lawyers don't fix it because there's nobody to pursue. So first of all, if there's nobody to pursue, I'm not sure how this is an increase in deterrence, right? So if the person runs away, the state also can't find you. The same way public lawyers can't find you. So I don't think there's really a difference in deterrence in this situation. And I think on our side of the house, at least you don't have the problems that we've talked about with making everyone pay the same insurance premium. So now I'm going to deal with the stuff that I'm going to talk to you about. So the first two things I'm going to group together are basically the same. So he talks about compensatory justice and philosophical justice, basically how you want everybody to be able to access the same kind of compensation under the law. So, Mr. Speaker, if we're talking about workers' comp and stuff like that, which I think most of the time they are, if there is a situation that the state thinks it is absolutely inconceivable that anyone ought be forced into. So for example, getting in a car accident and losing your leg but not having money for a prosthesis, then that ought be something the state provides to everybody, regardless of how they got in that situation. So if there's a problem with compensatory justice, it is not with the insurance system, it's with the healthcare system, or something like that. We don't think this really addresses the root of the compensatory justice system. Then he tells us about litigation, people can't get lawyers and that kind of stuff. I think our model provides an alternative way to give people recourse to the law by providing public civil lawyers, and do that better. But what did we tell you? So first we told you that this really screws up insurance incentives. And I don't think they really understand our point on the side of the house. Because our point is not that people have a right to lower premiums. The point is that people who can act safely will make decisions to change their behavior to act more safely so they can get a better insurance rating and pay the lower premiums. You take away the incentive for people to modify their behavior to get lower premiums if everybody pays the same premium. So we think the pooling equilibrium in this insurance case is suboptimal, basically. So we think that you actually take away this incentive that is really important, that the insurance system relies upon right now, and that's a really big problem. So for all of these reasons, Mr. Speaker, we'd like to...
I thank the second speaker for the opposition and invite the leader opposite to close the opposition mentions.
Thank you very much, Mr. Speaker. I'm going to sum up this round under three categories. I'm going to talk about the benefits that they try and posit as unique to their case and provide alternatives that provide those benefits without all the screwy things with their case. I'm going to talk about the specific losses, so those screwy things arising from the case. And I'm going to talk a little bit about individual responsibility as like a meta concept to finish the round, talking about insurance. So, first thing relates to the ability to sue. And I think Sophie and I present a compelling alternative account where it is the individual who is injured who has the capacity to pursue justice. And you don't need them to subscribe to a public insurance policy that has other problems in order to do this. You can provide them access to a lawyer who will take their case for them as long as they are willing to provide information and pursue that case through the court. So it should never be the case that someone cannot be restituted simply because they don't have the means at the particular instant. We have a solution for that. The second thing they talk about is the responsibility of those who commit harm. And we think this responsibility is actually reduced on their side of the house. The first reason it's actually reduced is that the government themselves will have a lot of cases to manage, and there will be no overriding requirement for someone to see the court case through to its end. So if I've been injured, then I have a pretty damn good incentive to make sure that the person who hurt me is brought to justice. While if Josh is working for the Public Service of Ontario, he's probably going to take a few years to do it. The last thing they brought up was that individuals shouldn't get punitive damages for something that's ultimately irresponsibility. That doesn't mean that they shouldn't get those restitutive damages. It doesn't mean that they should not be the agents behind the court case. Maybe that's a case about whether punitive damages are good or should go to the government. It's not the case that we're talking about today. What do you lose on their side of the house? I think you lose the choice over when you decide to sue. I think your personal interests might dictate that you don't want to cause the family friction arising from suing someone that you're related to or suing a coworker. I think we actually do believe in alternate causes of ways of conflict resolution. And you can't do mediation when the guy has already been paid off. It's the government who's going to be like, hell, they can't stand in for you in a mediation procedure. The second thing I think you lose is actually information for the trial. So I think they do admit it's problematic that those things intersect. We agree that it happens under the status quo. It's a bad thing. It's especially a bad thing to make systematic in all civil tort trials. The second thing, actually, and they've never touched this in Josh's speech, is your willingness to go to trial and to actually testify. Because once you've been compensated for your damages, the government doesn't have a mechanism to force you to go and testify against the person who injured you. And so it's very unlikely that they'll be able to as effectively bring that person to justice, which again reduces their incentive to actually act responsibly in the first place. Finally, individual responsibility. We think Insurance is a way to eliminate variance upon people with similar risks, but society as a whole is filled with different people. They ought not be different.
Alright, I thank the leader off for closing things off on off benches, and I would invite the PM to wrap up this round today.
Thank you very much, Mr. Speaker. I want to touch on three themes in my rebuttal. I want to first talk about Sophie's choice, or her argument about it. So, Mr. Speaker, what Sophie tells you is that we are taking away the person's right to sue, or the right to decide whether or not to sue, and that there are sometimes good reasons a person might not want to sue. And I would tell you right off the bat, Mr. Speaker, we ate this harm when we told you that we think it's better to have a fairer system than individual choice. But I will also tell you, Mr. Speaker, that this is a quantitatively minor point. We think that this just doesn't describe that many of the kinds of cases that we're talking about. In the interest of a utilitarian argument, it's not that good an argument. I would also tell you, Mr. Speaker, that a family is a unique situation, but that all of the principles Josh and I talked about are still the same. We still want to deter a dangerous driver, even if it's mom. The other thing, Mr. Speaker, is that we still want to compensate all victims, even if mom is broke. I don't think that either one of those things change in the analysis. I would also tell you, Mr. Speaker, about friction, that when it's the government who's suing and there's no choice about it, there's no friction because you're not suing your own mother. I would also tell you, Mr. Speaker, that in families, it is incredibly common for family members to coerce other family members not to exercise their judicial remedies, and we think that that problem is also ameliorated on our side of the House. Secondly, Mr. Speaker, I want to talk about their counter case, because it really wasn't much of a counter case. They never told you important things like how accessible will the public lawyers be? How resourced will they be, Mr. Speaker? Will they have to take any case? Because if they're anything like current public defenders, Mr. Speaker, I don't think that's a system that we trade. I don't think they ever responded to Josh's analysis about the fact that you can't sue a null defendant, Mr. Speaker. We think that government compensation for everybody, and Sophie told you that we think in the vast majority of cases where there is a defendant to sue, the government has an incentive to sue them. That directly contradicts Jake's arguments that these people won't ever get sued. We think that that's a contradiction on their side of the House. Last thing I want to talk about, Mr. Speaker, is incentives and deterrence. So they raise an argument about moral hazard on their side of the House, Mr. Speaker. And we told you that because people don't get punitive damages, there was no incentive for people to get themselves injured. But we would also tell you, Mr. Speaker, that we would every single day trade a slightly higher premium for everyone for a fairer system and unique and consistent and predictable deterrence for every single defendant. People shouldn't be able to get off scot-free because the person doesn't have enough money, because the victim doesn't have enough money to sue them. The victim should not go uncompensated because they lack the resources to sue the insurance company. Now, they spent a lot of time talking about the fact about why civil and criminal things don't mix, Mr. Speaker. And we would tell you, first of all, Mr. Speaker, criminal defendants are not required to give information against themselves in a criminal proceeding, but to the extent that they are, Mr. Speaker, we would tell you that we want more information about the wrongdoing in order to achieve a just result at the civil trial. And there are still important procedural protections for defendants in both criminal and civil trials. We don't think the government can just run roughshod over people's constitutional and procedural rights in every single case, even where the government is the same party. And Josh gave you lots of examples where we trust the government to be fair, even when it's both the prosecutor and the plaintiff. And we gave you examples of tax prosecutions. We gave you examples of when you drunkenly hit a government truck. We don't think that they ever gave you any analysis of why the government was going to treat people differently or why judges would let them get away with it. The last thing they tell you, Mr. Speaker, is that, so they told you that the government isn't going to collect on these claims, but Sophie contradicted that. And the last thing they told you, Mr. Speaker, is that there's a conflict between criminal and civil and that one is private and one is public. And what we told you is that the state has an interest in the civil remedy, in both deterrence and compensation and fairness. We stand behind that principle and we're proud to propose.
I thank everyone for an excellent round of debate. Invite the debaters up.